How does arbitration compare to trial when suing an employer? Imagine facing a workplace dispute and wondering whether to go to court or settle it through arbitration. Both options aim to resolve conflicts, but they do so very differently. Let's explore how arbitration stacks up against trial when suing an employer. Arbitration is a private process where a neutral third party called an arbitrator listens to both sides and makes a binding decision. It is usually less formal and confidential, meaning the details stay between the parties. It often takes less time, sometimes just a few months, and costs less because there are fewer procedural steps. You can choose an arbitrator with expertise in employment law, which can make the process smoother. The flexibility allows parties to set schedules that work for everyone, minimizing disruption to work or daily life. A trial, on the other hand, is a public court proceeding where a judge or jury hears the case. It follows strict rules, including formal procedures for exchanging evidence and questioning witnesses. Trials tend to take longer, sometimes years, and can be very expensive due to legal fees, court costs, and extended preparation. The process is more transparent because court records are accessible to the public, which can influence workplace practices and reputation. When it comes to outcomes, studies show employees often win a higher percentage of cases in arbitration than in court trials. However, the monetary awards in court tend to be larger, which might be important if you are seeking significant compensation. Arbitration decisions are final and binding, with very limited options for appeal. Court decisions can usually be appealed, giving you a chance to challenge the outcome if you believe there was an error. Confidentiality is another key difference. Arbitration keeps disputes out of the public, which can protect an employer's reputation. Court trials are open to the public, and records are accessible, which can lead to greater transparency and sometimes influence broader workplace policies. Cost and time are also major factors. Arbitration is generally faster and less costly, making it appealing for both employees and employers who want quick resolution. Trials can drag on, involve lengthy discovery processes, and rack up high legal bills. In practical terms, many employment contracts include arbitration clauses that requiring employees to settle disputes through arbitration instead of suing in court. This limits employees' rights to a jury trial and restricts their ability to appeal. Employers often prefer arbitration because it reduces the risk of large jury awards and keeps disputes private. However, employees might recover less money in arbitration and miss the chance for public accountability. In the end, choosing between arbitration and trial involves weighing the speed, costs, privacy, procedural protections, and potential outcomes. Each has its advantages and disadvantages, and understanding these differences can help you make an informed decision when considering legal action against an employer.